Good morning to everyone. We are still busy, people entering the room. This is the time of the morning where we start with a nice cup of coffee. And because I like people to participate in these webinars. So at the bottom of your screen, you should have a reaction button and you would actually have a coffee or you can have donuts. So we always like bringing stuff to people. So because it's a bit cold, we all love our coffees. You see, there's a cup of coffee for everyone. Don't say we're not good hosts. Good morning for is it Leonie from Aldo Properties, Richards Bay. Nice to have you. Relene, I haven't spoken to you in ages. Welcome. So nice to see you. So at the bottom of the page, you'll see there's a react button. If you click on it, it will have reactions, whether it's with effect, then you have your whole page doing this, or if it's purely a thumbs up. So that is something that's good to know. Good morning, Tsepi. Good morning, Colleen. Oh, Louw Properties, nicely, great to have you. Goeiemorgen, Elena. It's great to have everybody here. We have a very exciting topic. We have a good, we have a great host this morning, and we're so much excited overall. This morning is going to be a really good session. I just want to see here. If I can just get a thumbs up still that you guys can see the page, it will be Jaco van Staden from Louw and Heyl. He's the one that's joining us today as our expert, and I'll do a proper introduction just now. Good morning to everyone. Please drop your, say hello in the chat. Also use this morning. If you have anything that you have questions, please ask us. Ask us in the chat. We will then answer all the questions either on the end, or if it's something that we're busy talking about and they need some clarification, we'll address it. I'm very happy to have Armand now on the line this morning, or not on the line, on the Zoom this morning. Armand, now my co-director, business partner, and the awesome man himself is here this morning. And guys, believe it or not, he's got a Facebook page. If you've known Armand, he's been not on social media at all. So please go. We will drop the link in the chat. Go like his page. He's going to share some of the information we have. And we're going to have a lot of things that we'll be sharing on his page, my page, and on Xpello's page. If you know Armand, he's also the one that usually goes all around the country to go do trainings and talk to clients. So his number is always available. So you're welcome to always go and type in, contact him, and he'll connect with you. Just to say, remember, this is just the information seminar. This is not a training. So we are not going to give an attendance certificate or anything to that effect. It's purely attending. It's information that we're sharing. We're going to have an awesome attorney here with us today. So it's not a formal training, so we will not be sharing an attendance certificate. We will, however, this recording will be available on our YouTube channel. We will send out a mailer to confirm this as soon as it's ready. But also the good news is all our previous webinars are on YouTube. It's usually, you can just gain by this. If you forgot something, if you've got somebody new, go have a look at it while you're driving, while you're in the background, listen to what we are sharing. It's always great information. I also just want to say on the 16th of April, we are going to have Sean Lake with us. So next month, the 16th of April, we will send out that information as well, the topic and the time. But let's jump in today. So everybody is online. You have your warm cup of coffee. And I think it's cool. So I'm glad you have your cup of coffee. And I want to take the honor to introduce Jaco van Staden. He's a senior associate with Louw and Heyl. Louw and Heyl has been on our panel for in excess of 5 years, and they do a lot of our litigation in the Gauteng area. They are really a fantastic firm. I trust Jaco as I trust all of my attorneys on our panel, but Jaco does an amazing job. Jaco, thank you very much for joining us this morning.
Thank you, Lisa, and thank you for that kind introduction. Good morning, everyone that's in attendance.
So we are talking about a topic which I think is sometimes neglected and it can be very sticky. So we are going to look at the rental mandate, and I kind of wanted to jump into it immediately. Jaco, so one of the things that we usually talk about, and I just want to make sure because I suddenly lost you, uh, is
Yeah,
a rental mandate or authority to lease. I mean, it's basically the same thing. Does it need to be in writing?
absolutely not, Elise. You can conclude a oral mandate, but it's, with any agreement, it's preferred, especially with letting agents and their mandates, that it's preferred that it's in writing because there's so much obligations that the respective parties need to comply with, and just to avoid any confusion and disputes. But a written mandate is not needed between the landlord and the agent.
Okay, fantastic. And what you're saying there is so valuable. Um, we have agreement to prevent fight. Now, I want to say it from here, because I know we're going to address on it a bit later. A lease agreement, where usually I see often lease agreements deal with the fee part of your management, of a mandate. Is the lease agreement the place where you should deal with your fees?
Not in the lease agreement, but the mandate needs to stipulate expressly the fees that's going to be charged for managing the property for the landlord. It is the mandate is the agreement and the relationship between the landlord and the agent, and has no impact on the lease agreement between the landlord and the tenant.
Okay. Yeah, because I mean, the lease agreement is between the landlord and the tenant. The agent is clearly mentioned. So that is very important.
Absolutely. Yeah,
Now,
absolutely.
one of the things that I really see is people, they're so in a hurry, there's pressure, get the landlord, get the mandate, get everything done, and then they don't complete the mandate properly. Um, owner details. What is the implication if they don't complete that properly?
It's got a severe implication because the landlord actually defined it is the owner of the property or someone that's an agent or acting on behalf of the landlord that may enter into agreement. So if from the outset the details of the owner is not correctly inserted or detailed, it will have a effect on the agreement. For instance, when you have a landlord where he's the owner of the property and it's a company, and one of the directors wants to be the person that signs the mandate. In that instance, there must be a resolution between the directors authorizing the director to enter into the mandate. But from a legal aspect, is the person who's entering the landlord is entering the agreement. These details must be fully detailed, especially when you will get all that information when you do the FIC process. So everyone knows the FICA process, especially with state agents and attorneys. They are very strict on us at the moment. So you will obtain all those details when you do your FIC assessment, and then you have the details to insert into the mandate.
Yeah, yeah. And I have to say, people sometimes forget, especially for example, I've seen a dispute with husband and wife, and they go, no, 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 don't worry, my husband will do all the paperwork, and they then complete the mandate only in the husband. And then lo and behold, 6 months later, they go in a divorce, and now suddenly there's a fight, saying the husband didn't have authority because there was no paperwork, or who gets the money. And to cover an agent's self is make sure those details are in there complete. And then one thing that we also said, what is super, super important on a mandate is to make sure that your terms of services are completed. Make it clear on your mandate as to what is expected and what you should do. Because I think from this aspect is that often landlords go, yeah, but agent, you are useless. You are not doing X, Y, and Z. And often when the agents then want to complain, I refer them back to their mandate and say, well, what does your mandate say? What is your obligation? Did you make it clear? Or did you have a one sentence to say, I will manage your property? And I mean, that can be very vague, hey, Jaco?
Yes, it is very important to set up what exactly is expected of you as an agent, because the mandate is basically it's your constitution and your Bible with the relationship that you have with the landlord. So you cannot render any services which is outside your mandate. The landlord cannot expect that. So it's very important to set up exactly what is expected of you and when it is expected of you, and that you comply with it. That will protect you in with the relationship with the landlord in the future.
And of course, this is the place where you put out what you are earning. Now, I just want to say there's a purpose why I made it third. People, if we have learned anything from Verymark, you firstly tell the owner what you're offering and then you tell them the price. Don't start with leading of the fees, because owners don't always know what is you know, what it entails to manage a property. So if you already told them everything that you are going to do, and then you address the fees, then most instances you won't need to negotiate on your fees. Sean, this because Sean spoke about this yesterday as well, saying that a mandate is a sales tool. So please make sure that you complete it correctly. Jaco, if somebody then comes to you and say, listen, the owner didn't pay me my fees, you're going to rely on the mandate, you said.
Absolutely, absolutely. As I said, that's the constitution of between the relationship between the landlord and the agent. So if the landlord doesn't pay the fees, obviously he's in breach of the agreement, and then the agent has the remedies available to him or her to enforce the obligation for the landlord to pay the fees as agreed upon. What I normally see in other mandates is that fees is a very sensitive topic when it comes to the mandate. What I see normally, what certain agencies do, they set out the fee structure very detailed out in the mandate, and they let the landlord actually sign next to that. That gives them this just that extra security that the fees has been explained. They understand when and the amount they need to be paid, and then actually there's no dispute when it arises.
Okay. I think that is so valuable. And let's jump in. We now know what is the common disputes. Well, firstly, what the agent services entail. Common, Jaco, do you see in mandates? I mean, I'm quite sure you saw quite a couple of mandates. Have you seen a mandate where that has actually not been detailed?
Yes, I've seen a mandate that's very vague, very broad, and that is open for a huge dispute. It's very important, as I alluded previously, that you have to detail exactly what is expected of you. If you keep it very broad, the landlords can expect you to move mountains even. So be very specific, be very detailed in what you do. Don't leave it open for interpretation. It's the worst thing as an attorney or as a litigant is, what is actually interpreted, what the service is and what needs to be done. So try to avoid that and any vagueness. Be specific and be detailed.
Yeah, okay. Something I think agents also have to remember, just because you know what it means to manage a property does not mean it's the same thing the landlord has in mind. So go look at your regulations, what might be needed, so that in the regulations, what is the standard, sending the invoice, all of those things, and then those additional things that make you unique. Say that, over above that, we send the invoice every month and we will collect the rent for you. We will send reminders. I mean, there's no obligation on anybody to send reminders. That's an additional add-on. I think that is
Yeah.
that agents can actually do to advertise them better. And I don't think owners know what's the impact if you don't do that. So I think set out your services as much detail possible. They will see the value and you will easily get your management fee. Now, we also focus now a lot on the agent obligation, but a mandate is a two-way street, isn't that so?
Absolutely.
So
Absolutely.
a landlord also has obligations. Jaco, can
Yeah,
you
no, absolutely.
quickly think of obligations that should be in a mandate for a landlord?
The one thing that comes to mind is, especially when it comes to maintenance of a property. So when the one of the requirements or the services that the agent is has to do certain inspections to see whether the property is being maintained and receive complaints that certain mandate of maintenance needs to be affected to the property. Um, the most common thing is the communication with the owner of that maintenance that needs to be done. So I'll always say is the normal is you have to communicate within a reasonable time. But to protect the agents in this regard, I would say let the owner know as soon as possible of the maintenance that needs to be done, and he needs to do the maintenance because that's in the lease agreement. That's his obligation in terms of the lease agreement between him and the tenant. Failure to do the maintenance, in essence, it becomes a breach of the lease agreement. So for the agent, it's just to notify, make sure that the landlord is fully aware of what maintenance or any repairs that needs to be done, communicate it to him, and then the owner or the landlord needs to attend to it within a reasonable time.
Okay, so I'm just going to summarize as well, Jaco. We are getting a few people saying they can't hear you clearly. So just to summarize, because what you said now is so valuable, and I think it's so, so important, is the fact that a landlord's obligation to maintain the property needs to be in the mandate. Landlords need to know that it's not just a one-sided obligation, but if they don't maintain the property, for example, it's going to make you as the agent look bad, because often what we see is the tenants report the agent to the PPRA, or they report the agent saying, no, this agent is not arranging for the maintenance to happen. And back at the wrong, you actually say, well, I can't do anything more because I've spoken to the landlord and everything. So where are we going to draw the line? You don't want a tenant to go out there and badmouth your agency because the services are bad, and meantime it's not your fault. And I actually want to go as far as, please have a look. Always assess the business risk. Is it worth to keep this one landlord, which is not maintaining the property? So the property, you can lease it out for 10,000 Rand, but it is such a bad condition. If you get 8,000 Rand, you're lucky. But then you have a landlord that takes up all of your time, and he's upset because he's not getting things. So I think it's important to make sure that you have something in place to also protect you, to say, listen, landlord, I can recover your rental, I can do all of this, but if you don't bring your part, I cannot deliver my best effort. Also, if they then report you, you are protected because you made it clear as what is needed. Now, Jaco, the other thing that I know is a common dispute, and I stepped on a couple of those already this week, and I think it's because it's a very nice hot topic for me, is the renewal fee. Now, standard, I think everybody has put it in their mandate in the past without really thinking about it, to say that, an agent is entitled to a renewal fee. But now this clause is being scrutinized. And you said it so nicely. So the first thing I'm going to ask is, Jaco, so a mandate is in place. We get to the end of the term. So in the mandate, it says the agent is entitled to a renewal fee. But now the landlord says, agent, I don't want you to manage my property any further. It's the end of the term. Thank you. Goodbye. Can a landlord do that?
Absolutely. The landlord can terminate the mandate with the agent. There should be a termination clause contained in the mandate. If the landlord wishes not to utilize the services of the agent any longer, he can terminate the mandate, and obviously then the renewal fee will fall away because the landlord, the agent was in effect of renewing the lease agreement with the tenant.
That's something that you're saying. You're saying that the agent wasn't the effect for the renewal of the lease agreement.
That's correct. So the mandate is terminated. So all the obligations, specifically the renewing or attending to the renewing of the lease agreement, has been terminated. Therefore, due to the termination, the agent will not be cannot claim a renewal fee because the landlord is now taking over the management of the property and the tenant.
Okay, so Jaco, I haven't seen often that people actually define what a renewal entails. So in my mind, a renewal is there's certain steps an agent should actually take. And I do think if a mandate goes and it sets out saying a renewal of the lease entails, for example, a new credit check, inspection to make sure the property is well looked after, all of this, landlords will be more inclined to pay a renewal fee than purely saying, well, just because the tenant is remaining in the property, the agent is entitled to a renewal fee. Am I correct?
Yeah, you're absolutely correct. Yeah, the agent still needs to, render the services to the landlord, especially where it's important to do an inspection of the property to see the condition of the property. Determining whether because in a year there's so much that could have happened within the term of a year with the tenant. You could have obtained judgment against his name. Certain things could have happened. He could have been blacklisted for any reason. That could have happened. So there's also when the lease agreement or the mandate needs to be renewed, the agent still needs to again do its due diligence and do the necessary credit checks and inspections.
So Jaco, I'm just there's a question that popped up and I want to take one step back. When a owner gives a mandate to an agent to find a tenant and the agent then finds a tenant, to whom does that tenant belong?
The tenant belongs to the landlord. The agent was let's say the middleman to introduce the tenant to the landlord so that the landlord and the tenant can enter into the lease agreement. So the relationship belongs with the tenant belongs to the landlord.
So the tenant does not belong to the agent. And I think that is quite controversial because a lot of agents think that the tenant belongs to them.
No. The relationship with the agent is purely between the agent and the landlord, and then when the lease agreement is concluded, the relationship will be with the landlord and the tenants.
Fantastic. And I think also it's because remember, I think a lot of agents forget that, yes, you did the work, but you got paid for it. That's why in your mandate it says you get paid for a placement to find the tenant, so you get paid for that. And then you get paid to manage the admin, but the tenant belongs to the owner. Okay, so the tenant belongs to the owner. The owner then has a right to because also in a mandate, most of them are usually linked to the lease agreement, right? Saying, I hereby authorize agent X to find me a tenant for a period of 12 months for this property. And then in terms of that, they then enter into a lease agreement. Is that mandate then linked the time period? Is that valid for the duration of that lease?
Yeah, that's correct. It runs hand to hand with each other.
Okay. If that tenant then vacates, do they need to get a new mandate?
Normally the mandate is so open that you can get a new tenant. When the tenant vacates, the owner can, again, with the same mandate, instruct the agent to replace that tenant and do the necessary as what the agent did with locating the first tenant. So the same mandate can be utilized to obtain a replacement tenant.
Is it almost safe to say that you can use the same mandate, but there has to be a bit of a renewal? Because, I mean, clearly, an agent cannot just purely go and place a new tenant. He needs to have the authority of the landlord to say, hello, landlord, this tenant is vacating. May I proceed to go place a new tenant on the same terms and conditions as set out in the mandate signed? Is that correct?
Absolutely. So the communication between the agent and landlord is crucial. And always get that authority to proceed to replace the tenant in writing. That's always very important. Sometimes, you get a telephone call and you say, well, yeah, you can go for get a replacement tenant. Rather have it in writing by email or anything that you can actually show that you have written authority to proceed accordingly to obtain the replacement, and that the same terms and conditions of the mandate is still applicable.
Jaco, absolutely. Please, it's so important. I'm going to repeat it to say, if you've conferred something, whether it's WhatsApp or on verbal on a telephone call, please repeat it, confirm it in an email, in writing, that we make sure that everybody's on the same page. So,
Absolutely. Yeah.
okay, so renewal fee. Have a look at what your mandate is saying. I think everybody wants is different. I haven't seen where a renewal, what is meant by a renewal, actually defined in a mandate. I haven't seen that. I haven't seen what's the obligation. And usually, Jaco, I hate to go, if this happens, then this is applicable. But with law, unfortunately, it works that way, hey? So,
Yeah, no, that's unfortunately.
so please bear with me, agent. And I have to say, I'm quite lucky. I had an earlier conversation with Yaki, so I'm a bit more clever because I've got some of his answers already. So I just want to say, also looking at the questions, remember you charge a procurement fee or replacement fee, depending on what you charge it. And that is defined. What is intended by the work you do is defined, advertised, ongoing inspection, handover keys, lease agreement, whatever. Then and you charge that fee. I mean, you've earned it. Okay. Then what the next fee that you're going to charge is your maintenance of your management fee, which is then a monthly fee that you're going to charge, being 10 or 12%, doing whatever the reminders, the invoicing, the collections, and all of that, the maintenance part. So Jaco a bit earlier on said, well, the landlord can actually, during the 12-month period of the mandate, a landlord can actually go to the agent and say, agent, it has been real. I want to end your mandate. Can a landlord do this?
Absolutely. I'm going to bore some of the people that's on the webinar. So I'm just going to give a little bit of a legal back or legal aspect which is applicable. So when you look at a mandate, the mandate is also a fixed term agreement. Now, a fixed term agreement becomes the Consumer Protection Act becomes applicable when it's a fixed term agreement. So the agent in this regard will become the supplier, so the relationship, and the landlord will become the consumer. Now, the Consumer Protection Act says that a landlord or a consumer may at any stage during the fixed term period cancel the mandate, but subject to a reasonable penalty fee. The landlord must give 20 business days notice of cancelling the mandate. But as I said, which is subject to a reasonable cancellation fee. Now, the early cancellation fee is variable. It's not cast in stone. There's nothing that says, well, you're entitled to a few months commission that you would have earned. But most mandates that I've seen has covered that aspect, and it's very important that you specify and that the landlord agrees that if he cancels it, that he's liable for the commission for the remaining period of the mandate. That is normally the damages that the agents will suffer as a result of the early cancellation of the mandate. So it's very important to specify what early cancellation penalty fee you invoke when the landlord cancels the mandate.
So, Jaco, you now said that you've seen a couple of people saying that if a landlord cancels, a reasonable cancellation penalty will be the maintenance of the management fee for the duration of the lease. Now,
yeah.
I'm a bit worried. So, if the mandate is cancelled 3 months in, I mean, that means 9 months is left. I don't know how reasonable is another 9 months of a management fee. Do you think they will be queried on that?
Absolutely. There is there is some law that says that you have to mitigate your damages as well from an agency basis to replace the landlord equivalent to what the mandate was with the landlord. So you can't just sit back and say, well, I'm going to claim the remaining 9 months and I'm not going to do anything and I'm just going to pocket it. You have to be active in trying to replace that landlord with another landlord to mitigate your damages or your loss, if I can call it that.
I just want to say that we will not be going into clauses of mandate today in today's session. What we will do now, we'll be taking on some of the questions, but if Jaco have offered, and I'll share all of his contact details, that one of the service offerings is you can actually contact as an Xpello panel attorney, and for Xpello clients, they will actually review the mandate and you will give suggestions. And if there is updates necessary, they will give a preferred rate for charging them to update the mandate. So just on that, saying specifically with people citing clauses from the mandate. So Jaco, and of course, I'm very curious. Have you dealt with any matter where an agency actually took a landlord to court to claim the rest of the management fee?
I will be very honest with you, I've never seen it. I think, especially for the agency, it's a very sensitive step that you still want to keep your good name and you want to show that you will have a reasonable relationship. But as I said, anything in an agreement, if they have the penalty fee, you can still negotiate. So I think from the agency, it's always important that you can renegotiate the penalty fee to see, okay, well, this is actually the loss I will suffer as a result of you cancelling the mandate early, and negotiate a penalty fee. That's always open for between the parties to do. And I'd rather suggest doing that than approaching court, going through all that legal cost or whatever it might be, the stress and everything, and try to resolve it between the parties. And then everyone, as we say in the divorce proceedings, a clean break system.
So, because also, Jaco, I think, with sales, it makes sense because there you talk about proper commission. I mean, some commissions that sales agents earn is wow. But rentals, it's very seldom that you get such a big commission that is going to justify even the legal fees, I think. And so I think that is a very good point, which you're saying is, I think to make a business decision. But you said something else. You said if a clause is in the mandate. Now, Jaco, can I put a clause in the mandate that says, if the landlord cancels my mandate before the termination of the lease, the tenant has to vacate the property?
No, that is, the mandate doesn't govern the relationship between the landlord and the tenant. It's the landlord's decision of whether he wants to keep the tenant or not. It's not for the agent to decide whether the tenant needs to vacate or not.
So, Jaco, so if, say for example, people now took this as an idea and they go put it in their mandate. Please don't go put it in your mandate. Let me just put that caveat in. Please don't put it in. But say, for example, you see this. Will it be enforceable?
No, it won't be enforceable because the agent is not a party to the lease agreement. As I said, he was just the person introducing the two parties, and that's the role the agent played. It's between the landlord and the tenant, and that clause will, in no court, will hold any water. It will not be enforceable.
So, Jaco, and what is the risk if you have too many unenforceable clauses in your mandate?
Well, the thing is, it causes a bit of, I can say, an issue between the relationship between the landlord and the agency, because it will feel that the agents will push their luck to if I can call it that, to do certain things which they are not allowed to do. So it's very important to be, in a Consumer Protection Act, and I'm referring back again, it needs the clauses in any contract must be reasonable and must be enforceable. Any unenforceable agreement will look bad on the side of the agency. And as we know, if certain agencies have these clauses which are enforceable, there's word of mouth, people will start talking about it, which is not worth the risk to have. So rather comply with what you can enforce and what your legal right imposes on you, what you can do. Rather focus on that.
So that's a very good point that you are making. It's important to have a balance. Have a mandate that's enforceable and that you can make sure, because you also don't want to have a situation where your mandate is so unenforceable that the whole document is set aside. You don't want that.
Yeah.
I think be professional, put everything in, put as much details in, and see what conveys. And I think one thing that people sometimes forget, and I hear this often say, yeah, you need to put it in the agreement. Just because it's in the agreement doesn't mean it's enforceable. I usually laugh and say, if you do an ANC, an anti-nuptial contract, if you put the clause in, I might shoot my mother-in-law if she irritates me. Does not mean it's enforceable. Correct, Jaco?
Absolutely, absolutely.
So some people
I like
become very
I like that
creative.
example. Yeah, I like that example.
So just because it's in the agreement does not per se mean that it's going to be enforceable. And I think also, I think you have to do a balance. Certain things you're going to put in. So put in a cancellation, say 3 months cancellation penalty or 3 months. Please don't make it 3 months equal to the rent. Make it 3 months management fee, for example. Also, what is important to note that there's two relationships here. A early cancellation by a tenant deals with the cancellation penalty, and that's in the lease agreement. So if the tenant cancels, the losses suffered by the landlord, it actually doesn't have anything to do with the agent. The landlord can go and say, yes, I paid a placement fee of 12 months. After 6 months, you vacated. So technically, I lost 6 months placement fee. And that should be covered by the cancellation penalty. Jaco, am I doing that calculation roughly but correct?
Yeah, absolutely. It's the loss that the landlord suffers as a result of the early termination, and that's one of the biggest factors that needs to be taken in consideration when you calculate that early cancellation penalty fee.
And the important thing is, agent, if the tenant cancels, the remedy for the landlord is from the tenant. You are not being paid double. Okay, you have earned your money to place the tenant. You've earned that placement fee. You don't have to refund it. And if you now get the instruction to go place a new a tenant, you are again entitled to your full placement fee because you're going to do all of the work again. Yes, you can maybe say to your landlord, I will accommodate you a bit, but you are actually not being paid double. So I think that is something that one should keep into consideration. And often landlords say, yeah, but now you're going to be paid twice. But that's not the case. The placement fee, hopefully in your mandate, it's set out, you've done everything you were supposed to do. You have no control if the tenant decides to vacate 6 months down the line.
Yeah, so, I agree 100% with you there, Elize.
Jaco, then I think we touched on this already. Can landlord keep the tenants if the mandate has been cancelled and you tell the agent no longer management?
Yes, yeah, as I said, we've addressed it. So the landlord can definitely keep the tenant because the fact that the mandate has been terminated or cancelled by the landlord is the relationship or the agreement or the lease agreement between the landlord and the tenant still remains intact. So the landlord has now just taken over the management of the property, but the relationship there with letting the property to the tenant is still there and it's still intact. So definitely the landlord can keep the tenant if he's satisfied that is a good tenant. So any landlord would do anything to keep a good paying tenant, but in law he's fully entitled to keep the tenant.
Yeah, and also again, something that we discussed in a webinar I was involved in yesterday is owners are inclined or they choose not to renew with an agent if they don't see the value. So make sure that you convey the value that you're offering to your landlord. Let them realize what is the impact. So 2 months before the lease agreement actually terminates, I mean, remember, not more than 80 days, not less than 40 business days, you have to see if the lease is going to be renewed. Make it beforehand. Start having the talk with your landlord. Tell him, landlord, I am going to do this, this, and this. So I promise you, if they realize what it entails, more than often, they will rather let you do it. Even if you can, at this instance, get your renewal fee for making sure a new lease agreement is in place or an addendum, all the checks and balances if you lose the management. But that you at least build the relationship than just losing everything. What I've seen is the fact that so many agents just leave it to the last minute and landlords are starting to say, but I never hear from my agent. I only hear from them if they want money or if there's a problem. And that's not the type of relationship. We have quite a couple of questions that came through, and I think as they were popping up, I did address some of the questions. So I just want to quickly have a look. Armand, I know you also there in the back. If there's any question that I've missed, so the one question that was asked is the agency allowed to include a clause in the mandate agreement that states if a landlord decides to cancel the mandate agreement, that the landlord is still liable for a balance of the year's management commission? And Jaco, you said you've seen this before and you haven't had problems.
Yeah. No, I haven't had problems with that at all. It's quite all the mandates I've seen, it's quite a standard clause that's inserted in the mandate.
Okay, so and the thing is, as Jaco also said, then you can start negotiating. So if it's still 9 months left, I mean, our owner would rather pay you 4 months instead of 9 months, and at least you get some money out of it. Still, I haven't seen, like I said, I've seen quite a couple of mandates, and I think I haven't really thought about it in the past. But the cancellation fee should be then addressed. Armand, is there any other question?
I've gone through all the questions. I think all of them have been answered. Guys, if you've missed a question, please just repost the question if we haven't answered or touched on that specific question, please. But I think all of them have been answered during your discussion currently, yeah.
Thank you, Armand. And Jaco, as we're talking about mandates, there is different mandate. We have a mandate. Just the top of my mind is you have a mandate talking about placement and management. Then you have just placement, where it's only the job just to place it and not to manage it. And then, of course, it's got different things, whether it's a juristic owner or non-juristic owner. So basically, there's 4 mandates. Am I correct?
Yeah, no, absolutely. It all depends on who the landlord is, because it's very important to, from the outset, determine all the details of the landlord that's going to sign the mandate, because there's different. It's whether the Consumer Protection Act will become applicable, whether it not will be applicable. So you need to, from the outset, make sure that you get all the details of the mandate, so that you know which mandate you should conclude with the landlord, and especially what that landlord needs for you to do in the mandate.
Okay. And I think also, just a summary, what I've realized, and I mean, that's the amazing thing, is when we talk about mandate, is we really go and we sit still for a moment at the mandate. Is your mandate actually consists of different, I want to say departments, or sections. You have your one section where you put out all the details, all the information that you need, and it sets out then the things that you need regarding the property. Because also a lot of the information that is put in the mandate you use to draft the lease agreement. So make sure that all those questions and everything is then put in. Then you go focus on the services. And one of the things that I've seen, which I thought was very clever, And I'm a landlord myself, and the agency actually called me this way. They have a full package and they've got a budget package, and everybody always go for the budget package first, because we think most is easy. And then when you go and see what it entails, I went and said, well, there's actually such a small difference, and I really don't have time. Most investors don't have time. You think they don't have money? I promise you, they would rather buy one less McDonald's meal and you manage the tenant. I don't want to speak to my tenants. I speak to everybody else's tenants. I don't want to speak to my tenants. Um, Not because they're not great people, they're fantastic people, but that's where you have people. See what is the need of your owner. If your owner is it time, is it money, then give them the budget. But don't call it the cheaper one. Eh? Put it the budget package. Call it the standard package and call it the Rolls Royce. I don't know. See what how you feel with. And you would actually be surprised because overall, what we're seeing is we are in a life where everybody wants choices. I mean, you have 10 different choices just by ordering coffee. What type of milk? Do you want froth? Do you want cream? A cappuccino these days is 5 questions down the line. Same thing should be, options should be available. Jaco, we are coming to an end. Does a mandate have to be signed in wet ink? Or is PDF fine?
Electronic signatures is well renowned now these days. It's fully accepted to sign electronically. The courts, even with the courts now, they've accepted there's no issue in signing it electronically. As long as there's offer and acceptance, that's a legal binding agreement. Just one thing I want to raise, Elize, which is not in our topic, which also I've had some questions, is when the property gets sold, and when in this instance where the property is sold by the tenant to the tenant, is the agent entitled to commission? So that's a question that I've also received quite a lot, and the answer is yes, because the agent was the person that introduced from the outset the tenant to the landlord. So if the tenant wants to buy the property from the landlord and as offer to purchase is concluded, the agent with whom the mandate is fully entitled to commission, but you please specify the commission percentage beforehand in the agreement when that situation occurs. And also something else that I've also asked is, what happens if, let's give an example, the property is foreclosed on. It gets sold in auction, there's now a new owner. Just like the lease agreement, the new owner steps in the place of the new owner steps in place of the old owner. So the lease agreement will still proceed and the mandate will still proceed unless the new owner elects to cancel it, and then obviously the cancellation fees and everything that we've discussed becomes applicable. So it's also important to understand that when a new owner steps in to the shoes of old owner, it's still in effect.
Jaco, that is two fantastic points, and you are absolutely right. I think those things come up often and it's not addressed. I think especially with the cause of the sale, and I think it should be important if you are the rental agent and you had the discussion regarding buying, have records of it. I think it's going to be a bit more difficult to prove that you're entitled to that commission if you never, ever raised it with the tenant. And if somebody else comes and says, yeah, but why don't you just buy the property? I think then it might be a bit more difficult, but definitely have that in. Relene is asking a very good question, Jaco. Who pays the renewal fee, lease renewal fee, the owner or the tenant?
The owner pays the renewal fee, because it's stipulated in, as you said, well, in every mandate that should be a renewal fee. And it's not really defined, but it says that as soon as the lease agreement has been renewed, the owner, who is the party to the mandate, is responsible for that renewal fee and absolutely not the tenant.
Okay. Can one say that the fee should be shared between the tenant and the landlord? But the problem is the tenant is not part of the mandate, so you can't put obligations on the tenant, right?
No, absolutely not. No, the tenant is absolutely not a party. It doesn't have any relationship or any obligations in terms of the agent and the landlord. That's purely between those two parties. The tenant is completely out of the loop and doesn't have any responsibility to pay a renewal fee or a part thereof.
So that's important. We can't put obligations on the tenant in the mandate because he's not a party to it. Now the good questions are coming. Jaco, the other question that's come up is, so a landlord paid a placement or procurement commission in the beginning of the lease. Now the lease period has finished and now the tenant is going to stay on. Can the agent then charge the landlord again for a procurement or placement fee because the tenant is staying on for a further period?
No, that's only where the renewal fee comes in. Because you haven't placed a new tenant into the property, you haven't done your necessary marketing, whatever you need to do. It was basically just renewing the lease agreement, and the renewal cost will cover those services that you did to renew the lease with the current tenant. The replacement cost is only in the instance when you obtain a new tenant in the place of the old tenant.
Yeah, so I think procurement placement, very nicely, I just want to repeat, is when you place a new person. If it's an existing person that's going for a new period, it's a renewal. If I know I've seen this in the past, if you say, listen, landlord, to accommodate you, my renewal fee is 10,000, my placement fee is 10,000 Rand, you can pay me 5,000 Rand now, and you can pay me the balance 5,000 on renewal. I mean, that's a different story. Then you purely said, this is my placement fee, and you divided the payment terms. So that's something that that one can do, but renewal deals with the new thing. Colleen is asking a question, and Colleen, I'm not quite sure what is intended with the question. The question is, can new owners change terms of the lease if it is before the lease term expires? Is this now with relating to anything standard on the lease, or is it with regard to the mandate? I think for both questions, Jaco, I'm just going to answer here. Remember, an agreement can be changed by both parties, not one-sided. If both parties agree, it can be reduced to writing and signed, and that can be changed. So that is not unique, that's standard, but the key word here is by agreement. That's why usually most agreements has a clause that says any changes should be reduced in writing. Jaco, is there anything you want to add to my answer there?
Yeah, this also in the Consumer Protection Act says when you elect that period, you mentioned the two periods, not more than 80 days, not less than 40 days, to inform the landlord that the lease is coming to an end, whether you elect to terminate or not. If you elect not to terminate, you have the right to say, well, what other terms in the agreement we must change or what we can add. So you also, in terms of the Consumer Protection Act, you're also allowed to do that, to enter, to include or enter different terms of the agreement. But as you said, Elize, it has to be reduced in writing. It has been signed. You can just add an addendum to the mandate, which is common in common practice in managing properties or with the relationship going further.
Jaco, and then there's another question, and I think this linked up with something that you mentioned, which was very good, just to get clarity. So a property is sold. You don't need a new lease agreement because your landlord must now just step into the shoe of the old landlord. So your lease agreement stays in place. You don't have to change anything there. Your mandate. Can you use the same mandate that you use with the old owner with the new owner?
Look, that's also a thing that needs to be stipulated in your mandate, whether when the property is sold to another person apart from the tenant, is whether the new owner steps in the shoes of the old owner. So my answer is, as soon as the property has been sold, it for my mind is it's you basically it's same like the Hugo Quip. They step in the same shoes. Then the new owner has the right to manage to elect to proceed with the mandate or cancel it.
So Jaco,
Because the sale of the property doesn't cancel, or the change of ownership doesn't cancel the mandate. The new owner needs to cancel the mandate if he wishes not to proceed.
so Jaco, I think this is where I think one of the things we should consider is, firstly, if a property gets sold, I think the owner should inform the agent immediately, and it should be canvassed, because I mean a transfer takes about 3 months. Again, Armand is the guru with the transfers, and Armand, if I say something you don't agree with, please jump in here. So I would suggest the owner informs the agency it's being transferred. I do think with all the rights, it's going to be quite difficult for I mean, the lease agreement is going to be in place, and it always, normally it makes sense that the existing agent just continues to manage it. But the owner has a choice. So if the new owner doesn't want to take the mandate, technically the old owner is going to be liable for the cancellation penalty, not the new owner. That's how I will have it, Jaco. Do you agree with my assessment?
I agree 100%. And it's very important, at least from the inception of the sale of the property. Now, communication is key to inform the purchaser that there's a tenant and there's a lease agreement in place, and then for the landlord to also inform the purchaser that there is a managing agent's mandate in place managing the property. And they need to, as you said, they need to canvass it between each other and be transparent of what the relationship is, or what the stand is of the property as the date of purchase.
Yeah. And I think as an agent, at some stage you are going to find out about it. The moment you are informed the property is being sold, please raise it if it's in your mandate. Okay, so owner, what we got to do is please give us the details of the new owner, and that we can find out if we can continue managing the property. If the new owner says no, he doesn't want us to manage it, then old owner, we're going to hold you liable for a cancellation penalty, because our mandate is then ended. I think that should be the approach. I know it's a lot of admin, but rather be proactive. Don't wait. And unfortunately, I think in a transfer, Jaco, you might agree with me, in a transfer of the property, nobody cares about the rental agent. Nobody's going to inform them specifically what's happening, except if it's specifically noted. And I think the owner should really be taken to task on that.
Yeah,
Yes, sorry, Jaco.
There is some clauses in mandates where it especially says that as soon as the property has been placed on the market, the managing agent must be informed, and that is a requirement that the landlord must be, that to inform the agent of what the status of the property is.
Thank you, Jaco. So I have to say, an hour goes fast so quickly, and I always promise the people we won't keep them longer that is needed, and we are going to make this available. And I think there's so much more valuable information that we have to really stand still on a mandate. But as the hours almost passed, I want to start by firstly saying that here is Jaco's details. Please advise him you're an Xpello client or you attended the seminar, that he can give you that. I mean, their services overall are good, but that they can give you that special discount. I hate saying discount, but preferred fee. I think that is going to be very, very helpful. Jaco, as we at the end, what is your last words of wisdom you want to share with all the agents online this morning?
Be detailed in when you complete your mandate. That is very crucial, because that's if your mandate from inception is not correctly in place, it will cause issues going forward. So make sure that everything from the inception has been done correctly. You have your due diligence searches on the owner. All the terms and obligations is recorded, what needs to be done, what's the consequences, so forth. So from the outset, make sure that everything is in place, and it will make the relationship, and that's what it is. It's a relationship between you and the landlord, to make it smoothly and very comfortable going forward.
Thank you, Jaco. And from Xpello side, so we always say offer Xpello services in the mandate process. What I will be doing is that clause of Xpello, we will share that with Jaco. So if you send your mandate to Jaco, you will also make sure that that clause offering Xpello services to your landlord is incorporated. If you really want it incorporated, please send that to me. Me and my team will just put Xpello in there and send it back. The reason why I usually prefer putting it in is because clauses get moved. And it's not as easy if you meant any contract just to pop something in there. So we've got a quick turnaround. Send it to me and my team. We'll put the Xpello offering in there. If you are not sure how to offer it to your landlord, the Xpello services during the mandate process, please contact Armand or myself. We will give you your team training. We will empower them to be able to offer Xpello to your landlords. Remember, we never believe in selling Xpello, but offering them a solution, because landlords appreciate knowing that there's a solution available. So Armand's details, Armand, maybe you can just pop it again for everyone. Just for Armand's cell phone number, his email address. I just now realized my details aren't on the last page. Usually I'll mention my details on the thank you page. But it's there. Please contact us. We will empower and help you how to put it available. Jaco's details are on there. Jaco, from our side, thank you very much for all the great service that you've done for us. All the evictions, we have still have 100% success rate with all the evictions. Thank you for that and the feedback and the services you're rendering, and we're wishing you and your firm all the best. Everybody that's online, if there's anything else that you think that we have maybe missed or lost out or didn't address, please email me or Armand. Our details will be in there. We will reply as soon as possible, and have an awesome day. Thank you, Jaco.
Thank you very much, Elize.